Nick, your question, there's right. So we speak about Gaat, Voor, Koop all the time, and we've spoken time and time again. You can remind the audience, but we speak time and time again about how this transfer of rights works with Gaat, Voor, Koop. Now, what's interesting is in this instance, there's a tenant and the landlord that sold the property, so call him the seller, informed the tenant that the tenant would at least have 3 months from the date of the sale in order to move out. But now the new owner has told the tenant, no, I want you out in 1 month's time. What rights does a tenant have in situations like this?
Perfect. So let's just deal with the Gaat, Voor, Koop question, just for anyone who hasn't watched our older videos or is not familiar with the principle. So Gaat, Voor, Koop is a principle in South African law that basically says that when a property is sold and to a new owner, if that property has a lease agreement in place in respect of that property, that lease agreement passes over from the existing owner, the seller, into the hands of the new owner, the purchaser. So the landlord, in terms of a lease agreement, is automatically substituted from one party to the other. There's no need to do an addendum or anything like that. It automatically happens by operation of South African law. Okay, so in this case, in this question, we have a situation where there is a question of Gaat, Voor, Koop. One person sold, now the new owner owns the property and he is the landlord. He is entitled the obligations or the rights in terms of the lease agreement, but he's also subject to the obligations in terms of that lease agreement. Now, the interesting part of this particular question is there isn't a written lease agreement that was in place between the parties. Now, just because there isn't a written lease agreement does not mean there isn't a lease agreement. The lease agreement would simply be tacit or implied between the parties. And regardless of the fact that there isn't a written document, the new owner of the property is still the landlord in terms of this lease agreement. So it's not a requirement that there's a written lease. Gaat, Voor, Koop still applies. So we've got the new owner that is now stepped into the shoes of the old landlord. Now, the interesting part about this particular question is whatever the agreement was between the parties, between the old landlord and the tenant, is going to be what passes on to the new landlord. So we're told by the person who writes in that the landlord gave an undertaking that on email that once the property has been sold, there will be a 3-month notice for the tenant to vacate the premises. Now, we don't have the particular email in question, but because we're dealing with a lease agreement which isn't in writing, in other words, there isn't a clause specifically stating how the lease agreement can be amended in the circumstances. So this is a normal boilerplate clause. If you have a written lease, you'll see it says that in order to amend the lease agreement, it must be reduced to writing and signed by both parties. This is the most common way that that clause is written. If no such clause exists, it is possible to amend an agreement by virtue of something like an email. Okay, we've had substantive case law in this country saying that if you don't have specific requirements for the amendment of a document, something as simple as an email, and lately there's been quite a lot of controversy surrounding emojis and how emojis and communicating with one another can be consent and tacit acceptance of changes to contracts in circumstances. So if there is no requirement that they had to be in writing and signed by the parties, an email as simple as saying, look, fine, we're going to basically amend the notice period to a 3-month period, can be enforceable against, particularly in this case, it would have been enforceable against the previous landlord because he had created that impression. And then it might actually be enforceable against the new owner in the circumstances, because that is the agreement that they have taken over by virtue of the principle of Gaat, Voor, Koop. So in this particular circumstance, there are questions about what is the correspondence between the parties, and you know, there's nitty-gritty in the actual details of the case. So that would have to be looked into. But what is important for the purposes of this this particular questioning is obviously number one, principles of Gaat voor Koop, and number two, really being careful if you are a purchaser of a particular property and the previous landlord has made certain undertakings which might have changed the lease agreement. You will, as a landlord, undertake or take on those obligations that have been given to the lessee in the particular circumstances. So there may well be an ability for the lessee in this circumstance to enforce and say, no, my lease agreement required a 3-month period in order for me to vacate, and you can't actually give me a month's notice in the circumstances. The last thing that was pointed out in this particular question was that the notice that was given to them was done via WhatsApp. So there was nothing, it wasn't a letter, it wasn't on a letterhead of any case, it wasn't done in writing. And again, this is going to come down to what is the agreement between the parties. You've got a written lease agreement that says this is how notices must be sent. They must be sent in writing and by hand or to a particular email address. That is the standard that has to be followed. But in this particular circumstance, no written lease agreement, and so a communication was sent via WhatsApp, and that is a perfectly acceptable way, in the absence of a requirement in terms of a lease agreement, to communicate intentions to the parties. So nothing particularly wrong there as far as I can see in this question.
Fair enough. Awesome. Thanks so much, Nick.
Perfect. Thank you, Bruno.
Have a good one.
We'll see you next week.
Well, cheers.
Thanks. Cheers.